Welcome to my channel, Learn and Earn, to live your life on your own terms. You should begin charity from your own home. This is a famous quote which we have heard many a times. The Constitution Bench of Supreme Court has declared that the office of Chief Justice of India is a public authority under Right to Information Act. Thus, it has brought itself to public scrutiny. The highest office of judgment, the highest office of moral standards, the Chief Justice of India, who is the top judge of the Supreme Court, is now a public authority and can be scrutinized and open for public questioning through Right to Information Act. So is it a good precedent? I think it's a very positive judgment. I also believe, as said by Mahatma Gandhi, be the change you wish to see in the world. If you want the world to follow Right to Information Act, you, as the person who is going to judge, should also be above the law. Now the judgment says that the office of Chief Justice is a part and parcel of Supreme Court, which is a public authority. So office of Chief Justice of India is also a public authority. Transparency and accountability should go hand in hand. Judicial independence can neither be threatened by increased transparency under RTI nor can be secured by the secrecy. So, how had the Delhi High Court responded before? The Delhi High Court in 2010 also ruled in favor of bringing the Chief Justice of India office under Right to Information Act. It also observed that the Chief Justice of India doesn't hold the information on personal assets of fellow judges in a fiduciary capacity. Such information can be disclosed under Right to Information Act, as only the information held by a person in a fiduciary capacity is exempt from the disclosure. This verdict also upholds the same, stating that the judges of the Supreme Court are constitutional offices and not a hierarchy. So, disclosure of assets by any judge should not be considered to be vulnerable and dependent on the Chief Justice of India. Now, why a sense of caution is also required? A right proportion of transparency should be calibrated with judicial independence, as it forms the basis of public trust on the judiciary. The right to know under RTI should not be absolute, as the right to know of a citizen must be balanced with the right to privacy of individual judges. Personal information of judges should be disclosed under right to information only if it serves the larger public interest, or else it would lead to an invasion of privacy and can be used as a tool of surveillance. I think this is a very appropriate point. Now, judges are the people who are above any standards of public morality. Their privacy should also be respected, since they are the people who will be holding such high offices. Now, which provision balances transparency and independence? The disclosure of personal information is the discretion of the Public Information Officer under Section 81J of Right to Information Act. The information about assets of judges and official communication during the process of elevation of judges to the Supreme Court are treated as confidential third-party information. In such cases, Section 11 of Right to Information Act mandates the PIO to first issue a notice to the third party, the judge concerned about the right to information request for information. The view of the third party should be taken into consideration by the PIO in deciding on the RTI request. Certain non-exhaustive factors ranging from nature of information sought to its impact on the private life of the judge were also listed by the court for the PIA to take into consideration. Now, where will the verdict make an impact? I think it will transform the judiciary from being an institution insulated from public scrutiny to an institution for greater accountability. It will make decisions of collegium or judicial appointments public that can help in resolving tensions between executive and judiciary in the appointments. But despite binding the courts on accepting applications seeking information, the process of obtaining information may not be easy. While information on appointment transfers of judges can be sought, the reason behind these recommendations can be kept secret. As decisions of collegium are largely based on reports of Intelligence Bureau, they can be exempted from providing information under Right to Information Act. The effectiveness of this verdict on increasing institutional transparency also highlights dependence on actions of Chief Justice of India as the administrative head of the court. So I think it is going to set the right precedent by bringing judiciary the top position of Supreme Court under public scrutiny is definitely going to bring more transparency and accountability in the public domain and will itself increase the trust of the people in Right to Information Act. Thank you.